so people back in 6 months. Welcome, ladies and gentlemen, members, non-members, to this lecture on the 11th of September for the European Court of Human Rights. We have this very special lecture for you tonight. Indeed, tomorrow are the elections, and we all heard a lot of Europe. But the most of Europe we heard till now is about the economy. But what else is there to Europe? Well, there is also another issue, and mainly tonight about rule of law in Europe, and this time, especially in the time of human rights. Although Europe has been controversial, human rights in the European context have also been very controversial. Professor Tom Zwart, lecturer at Utrecht University and also specialized in human rights law, and in addition director of the School of Human Rights Research, will enlighten us on this topic, and he has also criticized the court in the past many times. Secondly, we have Julie Fraser, who will talk to us as well about the court, and she has been a lawyer for the Australian government solicitor, and she is also a researcher at the Netherlands School of Human Rights Research, and she's also writing a book about criticism, or she edited or contributed to the book about criticism on the European Court of Human Rights. So, ladies and gentlemen, without further ado, Tom Zwart.
Yes, thank you very much, Chris, for your very kind introduction. Indeed, I am engaging in criticism on the European Court, and I will display some of that criticism today. I'm very grateful to Julie that she has taken on the job of being my discussant. Julie and I work closely together on the book you mentioned, and it's a real pleasure for me today to be in her company as I am in yours. Why would anybody in his right mind criticize the European Court of Human Rights? It's such a benevolent institution. I cannot be any doubt that the court has been a huge success in the promotion of many, many human rights in many areas. That's exactly what the court aims to do. It's very clear. It's there to promote and protect human rights first, to broaden the protection offered by the European Convention on Human Rights. So again, if you're in human rights, nothing can be against that. The former president of the court, President Costa, has summarized this approach as saying, well, we are geared toward effectiveness, and we do not mind too much about formalism and legalism. And that's probably where the problem lies, because I would say that the court is a court first, and when it promotes human rights and protects human rights, it should do so within the framework of being a court. That's not what the court does. So just let me give you one example of what I mean. We have a framework in Europe, which is an EU framework rather than a Council of Europe framework, which is called the Dublin Regulation. Under the Dublin Regulation, when an alien enters the territory of the European Union, that person, when he wants to apply for asylum, is supposed to do so in his country of first arrival. So if somebody comes in Greece and then moves to Ireland, then Ireland is supposed, under the Dublin Regulation, to send that person back to Greece. Now, for a time, it was clear that this Dublin Regulation was not working, because many people came in on the Greek side and just crossed the Turkish-Greek border. And the Greek, as they themselves have admitted, did not a very good job in protecting these asylum seekers and providing them with the basic necessities. So after a while, this idea that asylum seekers had to be sent back under the Dublin Regulation began to fall on criticism. And it was actually the European Court of Human Rights that one day, in a case called MSS, the Belgium and Greece, pulled the plug. They said, this is no longer working. These asylum seekers are suffering in Greece, so the countries of the EU are no longer supposed to send them there, because that would be a violation of Article 3 of the European Convention on Human Rights, which protects against torture and inhuman and degrading treatment. Now, at first sight, nobody can object to this act of humanitarian intervention. But in my view, it's not up to a court to set policy and politics and then to move on it. It's not what the court is supposed to do. And the court has openly admitted that it was about to intend on abolishing the governing regulation. That's not for the court to do that. The problem I have is that a number of colleagues of mine, academics, but also judges, national judges in Russia, in Britain, in France, in Spain, and even some of the court's own members, are criticizing the court, and the court is simply dismissing the criticism as coming from narrow-minded people who are ignorant. Well, I must say, I may be narrow-minded, but I'm not ignorant, and so are many other people who are experts in human rights, who know what we're talking about. I would say that it is in the interest of the courts to take the criticism seriously, because otherwise the court is getting a very, very rocky resistance. Because in my view, what the court is suffering from is from a lack of legitimacy. The legitimacy of the court is slipping away. Let me briefly explain what I mean with legitimacy, because legitimacy is an often used word, but not always very clearly defined. And I go back to the political science literature. Easton, the name probably many of you have heard of. James Easton has once defined legitimacy as diffuse support, as popular support people give to institutions like courts, and he has distinguished that from specific support for outcomes, in the case, of course, for judgments. And political science research shows that for a court to be effective, it needs legitimacy, because courts do not have the power of the sword nor the power of the purse. So it has to be persuasive. And I believe that the court is losing its legitimacy. So it's in real trouble. I find it hard to prove that, because usually courts are monitored. The popular support for courts is monitored. If you go to Canada or the US, we all know what the popular support for the US Supreme Court is from day to day. It's around 89%, which is extremely high value. We don't know any such thing about the court because it's never measured. But I have some anecdotal, some circumstantial evidence to support the position that the court is losing its legitimacy. And that has to do with the fact that also politicians become more critical of the court than they used to be. There are two countries within the Council of Europe leading the charge, being Britain and the Netherlands. And even on the 24th of May, which is a historic date, I must say, the British Prime Minister David Cameron said in the House of Commons that Britain will not implement the court's first decision, which is about the need to grant voting rights to prisoners. It's not going to execute that judgment, which is for the first time in the history of the court that a country actually opposes and refuses to implement a particular result. In my view, these politicians, although the court feels that they're undermining the authority of the court, are actually the canaries in the mine. They show that the public support for the court is slipping, and we should be grateful to these politicians rather than we should be critical of them. The court should take this criticism seriously. So the court needs to increase its legitimacy. Now, there are several ways in which that can be done. Fortunately, political scientists in America have found ways for courts to increase their legitimacy. And basically, the story is, the more you distinguish yourself as a court from other political actors, the more legitimate you will become. In other words, if courts behave themselves as craftsmen-like legal institutions that apply legal principles in an impartial manner, then their legitimacy will increase. That can be done by the court very easily. It's very, very necessary. I will just touch upon three areas because I don't want to take too much time from Jude. The first is fact-finding. A lot of the cases before the European Court of Human Rights concern the extradition, the deportation of asylum seekers. And there the court finds it difficult to rely solely on the proof, the evidence supplied by the state, because the state feels that the asylum seeker can be deported, and of course the applicant, the asylum seeker himself or herself, doesn't agree with that. So in order to have an impartial weighing of the evidence, the court has to rely on other sources of evidence. And what the court is doing since a number of years is relying on reports submitted by Amnesty International and the United Nations High Commissioner for Refugees. Now, let it be clear that I have nothing against either of these organizations. I love Amnesty International and I love the United Nations High Commissioner for Refugees. But they have their own policy and political agenda. It is wrong for me, in my view, for a court to rely on evidence supplied by organizations as part of their political work. That doesn't work. In addition to that, the evidence, so-called evidence supplied by Amnesty and UNHCR is never case-specific. It's not about the case that is presented to the court, it's always about the country itself. And you can't work from that perspective. The second issue I have with the court is that it doesn't follow its own precedents. Courts everywhere in the world, in order to retain their legitimacy, have to build on their existing case law. Of course, they can depart from previous decisions, but they have to do so expressly and not apply it. And the court actually is very, very bad at that. Sometimes it looks as though the court isn't aware of its own decisions in previous cases concerning the same set of facts. I know lawyers who have argued cases before the courts about the same set of facts, winning some of these cases and losing some of these cases, which of course doesn't bode very well for the legitimacy of the court. So it should be much more aware of its precedents and follow it. I mentioned the case about the asylum seeker from Afghanistan who was the MSS Belgium-Greece case. There Belgium decided to deport the asylum seeker to Greece on the basis of a decision taken by the European Court of Human Rights 6 months previously, and then the court said, this is outrageous, you're not supposed to do this, and a complete contradiction of its own case. And finally, I would say the court also needs to get its act together in the area of interpretation. It keeps reading rights into the European Convention that were not there when the European Convention was drafted. We now have, in the case law of the court, the right to environmental protection. I love it, of course, but it's not in the European Convention. We also have the right to social security. So all kinds of welfare and social security cases are being brought before the court, while there's no mention of these rights whatever in the Convention. Actually, I refer to the English case where Prime Minister Cameron said we're not going to follow up. That was about the right to vote in the European Convention. There is no such right. There's no right to vote in the European Convention at all. There's a duty for the states to organize free and fair elections, but that's not the same as an individual right to vote. Actually, don't take it from me, take it from the court itself. For 25 years it has denied that there's a right to vote in the convention. And now suddenly, in a number of cases, including this first case, the court comes to the opposite conclusion. In order to maintain its legitimacy, of course the court is supposed to interpret the European Convention, but it should develop clear manageable standards which we can all understand, which allow us to judge whether it's doing this in an objective manner. But it's not doing it. It has come up with a concept it calls consensus. So when a particular situation brought before the court is answered in a particular way by a large majority of the member states of the Council of Europe, and if the practice of the state, the defending state, is not similar to that practice, then there's a violation of the European Convention. This might make sense if the court itself sticks to this particular approach, but it doesn't. And there's one, I would say, bad example of this called the Christine Goodwin case. The court has been confronted with a number of cases brought by British subjects when undergone sex change operations. And unfortunately for them, it was impossible to then subsequently change their registration in the public registrars of Britain. Of course, I agree with those people who feel that this is terrible. After undergoing traumatic treatment, also having to undergo withdrawal. The court, however, wisely in my view, pointed out that there is no such thing as a right to re-register within the European consensus. And after 3 cases had been brought before the European Court, it felt that it had enough. So it said, okay, there may not be a European consensus, but there's an international consensus, because in Australia and New Zealand, you're allowed to re-register. Well, I don't know, I mean, I love Australia, I love New Zealand. It has nothing to do with the European consensus, and I doubt, again, although not in both countries, whether they constitute an international consensus. If you go to Africa or Asia, probably many people will not agree. Now, I get a lot of criticism, and of course I like that because I'm an academic. Some people say, well, we have more important business to attend than listening to your criticism about the legitimacy of the court. The court is faced with an enormous caseload. If the court would stop taking in cases tomorrow, it would still need 50 years to deal with the backlog that has been building up during the past few decades. So rather than spending time in these tedious discussions on legitimacy, we should focus on the workload. Well, actually, the workload and the loss of legitimacy are closely associated. If you get rid of the legitimacy problem, probably you will also get rid of much of the concerns concerning the work. Let me just give you one example, and I can mention a lot during the discussion. The European Court of Human Rights is allowed to issue so-called interim measures under the rules of the court. These are requests made by the court to states parties in urgent cases, especially when there are asylum seekers about to be deported to countries where they have to fear for their life. The court can friendly ask the state party, the Netherlands for example, not to do so until the court has decided the case brought by that particular applicant. There's nothing wrong with the system, it's a great system. Unfortunately, in 2005, in a case called Mar, the court decided that states are not invited to follow these interim measures, but they are supposed to do so in a legally binding manner. So they're forced to follow them. And in doing so, the court overturned its own precedent in the previous case called Cruz. Interestingly, until 2005, annually about 100 requests for interim measures were made by applicants in their roles. From 2006, the year in which the court handed down the Mar decision, the number rose to 5,000. I would say this is something the court has brought upon itself. But that's not what the court felt. The president of the court, President Costa, issued a letter to all state parties and all lawyers operating before the European Court of Human Rights, calling on them to exercise self-restraint. I would say the court should have asked itself to exercise self-restraint. Thank you very much.
Thank you very much for the invitation to come and speak to you all today, and also to Professor Zwart for including me in the presentation. I'm also very pleased to be here with you. I would also like to thank Tom for his insights on the role of the European Court of Human Rights and its perceived legitimacy. Tom and I agree on the fact that the court has long been one of the most advanced and successful human rights regimes in the world. It has been emulated, and its jurisprudence argued in courts far beyond the bounds of Europe. Australia. Its achievements in human rights notwithstanding, the convention system is far from perfect. Tom argues that the court's legitimacy is slipping. He notes that rather than mechanically applying the law, it is cutting corners and being sloppy. He argues that breaking with precedent reveals the court to more of a political organ Tom and I do also agree, however, that despite the success of the court in giving flesh and blood to the bones of the Convention, the Strasbourg system is in jeopardy if criticisms such as these are left unanswered. Tom's premise is that while the court may be effectively promoting human rights, it is doing so less and less while operating as a court. And with this, I respectfully disagree. In my response, I shall respond to Tom's proposition that the court is experiencing a crisis of legitimacy and failing to uphold appropriate judicial standards. I do also agree with Tom's assessment that the importance of legitimacy for the court is crucial, as it is indeed for all courts. Most critics who question the court's legitimacy refer to a lack of sufficient basis in society for a court's ruling. Now, Tom, as he mentioned before, uses a political science meaning of legitimacy, which is popular support. I think, therefore, it's interesting to consider the difference between legitimacy and popularity. Tom himself notes that there are no longitudinal studies or no direct evidence that the court is losing legitimacy. He notes that this is his assumption. He claims that the court is losing legitimacy with the general public. Now, I would like to challenge his assumption and submit that rather than losing legitimacy with the general public, criticism of the court is raised by governments who don't like to lose their cases before the court. While Tom claims that the court should not make unpopular decisions, I submit the opposite. The court should not make decisions because they're unpopular. We shouldn't confuse legitimacy on the one hand with popularity on the other, because the court is not Lady Gaga. The court's work is supposed to be a check on national legislators and popular politicians. The court must represent democracy under the rule of law, which is distinct from democratic decision-making. Among its earliest decisions, the court held that the rule of law implies that an interference by the executive authorities with an individual's rights should be subject to effective control, and this control should normally be assured by the judiciary. Thus, the court does not always need to enjoy popularity with the majority, as its role is to protect minorities' rights, which may be unpopular. And equally, as a supranational court adjudicating the practice of member states, popularity among those states may also be unrealistic. As noted earlier, whether the legitimacy of the court's rulings have been weakened among the general public remains unsubstantiated. One can easily believe the opposite, that the court is still viewed as a legitimate protector of human rights in Europe, due to the impressive number of cases brought before the court by applicants every year. At the beginning of this year alone, over 150,000 applications were presented to the court. And as Tom also noted, the court is not bound by previous decisions by its precedents. While such decisions are not binding on the court, I also agree that they should not be departed from without good reason. The legitimacy of judicial proceedings is guarded by principles of consistency, legal certainty, and predictability. Legal certainty is vital if national courts are expected to follow and apply Strasbourg case law, and to do so without the fear that it can be easily overturned or departed from by the court. What is important is that the process has integrity. Theorists argue that a legal norm is valid because it was created in a particular way. Therefore, even if one does not like the decision or the outcome, one cannot fault the process that led to it. I think that this is the point that Professor Zwart was also keen to make regarding consistency, process, and follow-up precedent. However, it's also been noted that the precedent should not be blindly followed because they can, and sometimes they should be, distinguished. It's necessary for the court's case law to evolve to deal with new factual scenarios and legal situations as they arise. The court has often reiterated that the Convention is intended to guarantee rights that are not theoretical or illusory, but rights that are practical and effective. In such situations, the explanation and clarity of reasoning is important. The court should not surprise parties by its arbitrary decisions, but should rather clearly articulate the logic behind all of its decisions. Judge Meyer of the court has confirmed that the court dedicates a significant period of time to ensure consistency and coherence of all of its decisions, and indeed the court refers extensively to its own jurisprudence and its judgment. I think it's also important to retain a bit of perspective on these sorts of issues. The current leading cases of the court were also once criticized at the national level. There are many examples, such as the Henderson case. But now those cases are part of the court's APIS, or or the accumulated acts and decisions that constitute the law that convention sets on. This body of law is the basis for human rights protection in Europe. It can therefore be posited or even anticipated that these cases that occur as today will, in the future, also form part of this important body of making decisions. The final point raised by Tom was in relation to interpretation. And now much of his criticism regarding interpretation of the Convention relates to the living instrument approach of the Court. The Court has long stressed that the Convention is a living instrument and that it's to be interpreted in the light of evolving circumstances. Its meaning is not to be confined to what was after the war in 1950. As I'm sure you know, a lot has moved on. It's been argued that this living instrumentalism doctrine creates new rights that interferes with parliamentary sovereignty. However, by interpreting the Convention of present-day circumstances, courts are merely doing their work. Cases are brought before them, new questions are presented, judges are required to answer. Their decisions will often make law, whatever their decision is. This applies to both national courts as well as the Strasbourg courts. I think it's overly simplistic to say that courts should apply, but not amend the law. So also, rather than the court's judicial activism causing the increase in the court's workload, as was previously claimed, I suggest that the overwhelming number of applications from particular countries contribute to the backlog of the court's work. Over 60% of applications pending this year come from just 5 countries: Russia, Turkey, Italy, Romania, and the Ukraine. I believe that this reveals systematic human rights issues within those countries, rather than rampant judicial activism on the court's part. It should also be recalled that around 95% of applications for the court are deemed inadmissible, so I think it's hard to argue that the court is running away with itself. And just like Professor Zwart, there are those who claim the court is going too far. On the other hand, others claim that the court is not going far enough. To use an example of Tom's as well, ABC in Ireland, in this case, despite a majority of European countries permitting abortion, in this case, the court ruled against women's choice in Ireland. As this demonstrates, the court must walk a very fine line and receives criticisms from both ends of the political spectrum. In conclusion, I would submit that the court needs criticism and that there is in fact no inconsistency between being a proponent and a critic of the court. I encourage everyone who supports the protection of human rights across Europe to join the debate and to ensure that the court remains strong, respected, and effective. Some questions I would pose to you are: do you think that the court enjoys support across Europe? Do you think that the court should be progressively led, that the court should progressively lead to the protection of human rights in Europe? Or do you think it should simply clean up in persistently lagging states? Also, if not the court, who do you think it should fall to support the rights of the most vulnerable people in Europe, such as asylum seekers? And finally, are there any political solutions to the problems facing the court? I'd like to conclude by thanking you all for your attention, to Tom for your discussions, and I look forward to hearing all of your views on these matters.
All right. Well, thank you, Judy Fraser, Tom Zwart, for your contributions and ideas. I hope it proved to be an inspiration to all of us. Well, let that provide food for thought during the break now, and we will commence at, what time is it? In 10 minutes time. So, in 10 minutes I'll see you all back and join the discussion. Alright, welcome all. We will now commence with the discussion, which we'll do till, I guess, around 9 o'clock. And after that, well, we have the other, the end speech. I will just first start with a motion, which the speakers can react to. And after this, you can pose your own questions, criticize, or praise those things. Alright, so my question, or my motion is, we have heard a lot of criticism of Tom Zwart. We heard criticism and praise from Judy Fraser. We heard that the court was somehow inconsistent, but There are also other speakers who say something else. I know from. They say the court is going too far indeed. They're making their own law. Their cases are too broad, and they actually interfere with the state himself to make laws. Actually, states who are made by democratic election, who have the democratic allegiance. And what do states have? That's the question. So, should we maintain to have the court actually, or should we not just abolish the court? Firstly, Professor Tom Zwart, and then Julie Fraser.
Of course, I would not support a motion abolishing the court. I think the court is a wonderful addition to the landscape of human rights protection. It's an example to a certain extent, as Julie said. Even the High Court of Australia, the August High Court of Australia, is following some of its judgments. I have an issue with the way the court operates, with the court as an institution. And don't take it from me, again. When Julie says that I do not like the living instrument approach of the court, I agree, I don't like it, but that's my personal preference. What I reject is the fact that the court adopts a living instrument approach and doesn't apply the standards it introduces itself. And if there's no legitimacy problem with the court, I would say, why not put the acquis, the whole case law that has been developed by the court over the past few decades, to a Europe-wide referendum and see what comes out of that. If there's no problem with legitimacy, we don't have to be afraid that the people overwhelmingly will support the case law of the European Court of Human Rights. I know that many judges in the court are afraid of that happening. I'm not afraid. If there's no legitimacy issue, we should do that. The fact that countries like Russia produce a lot of cases, yeah, it has to do with the fact that the Russian people represent 1/4 of the people living within the Council of Europe, and they do not produce 1/4 of the cases brought before the court. So today they exceed the 1/4 quota. I would be worried. Now I would only welcome them. What I do not welcome is the members of the court constantly bashing Russia because so many cases come to the court. Rejoice. I would say the more cases come from Russia to the court, the merrier. They may not all merit attention, but then they will be declared inadmissible. So I don't support the motion.
Thank you very much for the question. I also don't support the motion either. I think I have somewhat of a unique perspective being an Australian lawyer. And in Australia we do not have any human rights legislation, nor do we have any human rights protections in our constitution, with a few minor exceptions. So therefore coming to Europe and seeing an institution like the convention and the court system is something that we are incredibly in awe of in Australia. And I think that there should be absolutely no question about doing away with it as an institution. I think though that you need to differentiate between the court and its democratic legitimacy. It's not a democratic body. It wasn't elected. However, the countries that did ratify the treaty were all democratically elected. Those governments signed up and agreed to be bound by this. But as I said, the court is about democracy under the rule of law. Its decisions do not have to be democratic. And I think it's important because the court protects unpopular rights at times. And therefore, that's its exact purpose, is to at times disagree with the majority. So therefore, I think that it shouldn't be done away with, and nor should necessarily be an issue if the majority of Europe doesn't agree with some of the rights and protections that are in.
Thank you. Does anyone has a reaction or wants to pose a question?
Hello, my name is Wouter Eijens, and my main concern is that you defined, Tom Zwart, you defined legitimacy as popular support among the whole population. And but yet your arguments, they were good arguments, but I personally have to say, I read the paper every day, but I never heard of those arguments. And I doubt the majority of at least the Dutch population would have heard of those objections to the court. And then, well, it just seems odd to use this definition of legitimacy with those arguments. to me it seems that the biggest concern among at least the Dutch people with the European Court is that they simply do not want a non-Dutch court ruling Dutch cases. And it's just as simple as that. What's your response to that?
Well, Lars, thank you very much for your question, which is an excellent question. We don't know if the Dutch people like or they don't like. Again, I do not have hard and fast evidence to support my hypothesis that the court is losing legitimacy. I'm basing myself on circumstantial evidence, which is politicians. Politicians usually sense what is happening much better than judges do. But let me give you two examples to illustrate my point. 2 years ago, a court in The Hague came to the conclusion that squatters, people who illegally enter into property of other people and then occupy it, have a right to their home and their privacy under the European Convention on Human Rights. This was a very unpopular decision. It was debated in the press for weeks. I believe there was even a poll taken, and the large majority of the Dutch people rejected that particular decision. Now the court will say, listen, this was a local court, this was not us, but the local court, I don't like the fact that they are calling out, the local court simply applied the case law of the European Court of Human Rights in this case. According to the European Court of Human Rights, squatters have a right to property, to home privacy under the European Convention. I cannot see any majority for that in the country. Now you can say this is the odd, unpopular decision, and of course Julie also made the point, you sometimes have these frustrated states complaining, whining about the fact that they lost the case in Strasbourg. That's not the issue I'm making. Of course you have this of all times. The problem I have is the following. Just remember, in 2000, the US Supreme Court decided a case called Bush v. Gore. And it decided, it's a very complicated case, but it decided at the end of the day that then Governor Bush had won the Florida elections and therefore gave the presidency to George Bush. I can tell you that 50% of the Americans hated that outcome, those people who had voted for then Vice President Gore. Did it have any effect on the popularity of the court? None whatsoever. That means that the court is held in such esteem by the American public that it can hand down whatever decision because they believe that it's a credible court. Second point, look at the UK. The UK government had warned the court that it would be a very hard sell to the people of Britain that it would have to introduce voting rights for detainees. They had abolished them in the 16th century. So to restore them, give them some kind of voting rights, would be contrary to the national feeling. And it shows the resistance against this first case, in which the court decided that Britain has to grant voting rights to detainees, was opposed by, I believe, 333 members of Parliament, the House of Commons, against 6, which is an overwhelming majority. And I will tell you what is telling about that. It was not only the Conservatives that were not happy with the decision, which perhaps is not surprising. It's also the Labour Party. The Labour Party in 1997 introduced the European Convention on Human Rights into the national legal order in Britain. The minister responsible for doing so is called Jack Straw. Jack Straw led the opposition to the Hearst case from the backbenches of the House of Commons. Why? Because their constituents were deeply unhappy with the decision. That's what you get. Could it have been prevented? Of course, there's no voting right in the European Convention. Not one whatsoever. And again, don't take it from me, take it from the court itself.
Great.
My name is Anna, and I have two short questions. First, are there a lot of cases before the court against the Netherlands? And does the Netherlands always implement the decisions of the court?
Two short answers. There are, I believe, 107, I believe, in final count, cases pending against the Netherlands. Pending means that they can also be rejected as being clearly inadmissible out of hand. The Dutch do not get many convictions by Strasbourg. And as far as I'm aware, the Dutch are very good at implementing the judgments of the court.
Thank you very much for your interesting lectures. I have a question about how to interpret the rulings of the court. I believe the British Lord Chief Justice recently, or a while ago, stated that actually the Strasbourg Court's rulings, even though all the members of the Council of Europe are bound by the Convention, the rulings need only to be taken into account, so they should only consider it. And there should actually be leeway, some subsidiarity for these national courts to make another distinction anyway. So in that case, would then the British decision to throw out the Hearst ruling, would that really be a landmark, or would that be a salty? Secondly, they also proposed making it possible or more usual for the court to not consider cases if a compelling argument can be made that these cases were actually already properly considered by national courts, that it was already professionally done, and that another court going over it wouldn't add much to it. I'm not sure why this isn't done already, so I would appreciate any expounding. Thank you.
Well, thank you very much for your very insightful questions. There have been a lot of complaints coming from judges from the UK. I would say that 90% of the judges is clearly unhappy in the UK with the way the court operates. There are 10% of judges who are in favor, and they get invited to Strasbourg to give presentations, by the way. That also is telling, because the British judiciary was the main pushing factor behind implementing European Convention in national British law. Now, the point made by the judge you referred to, you're absolutely right. We have to distinguish between cases in which the country gets a judgment against itself, like the Hearst case. There cannot be any doubt that under the European Convention, Britain has to implement that judgment. If it doesn't, and it seems that it won't, then it is in violation of its treaty obligations for its law. The other point, and that's the point made by the judge, is that there's also a tendency by courts across Europe to already take into account judgments against other states, against Finland or the Netherlands, and then proactively apply that case law. That is what we call persuasive precedent. That has been done eagerly by the British courts, but they have said that they will stop doing that because of the inconsistency. They don't understand sometimes how these precedents can be applied in a manner which is consistent. And there's also, may I say, a nationalistic element to it. British judges are the best of the best, perhaps also with the Australians. So sometimes they feel that what the court is doing actually is poor quality. So they're no longer willing to sacrifice their great tradition to the poor quality judgment of Strasbourg. They will never, they're British, they will never say that in public, but that's what they tell me in private. Okay, yeah, but briefly, perhaps you can follow that. I'm not sure whether that was a proposal for the Brighton conference. I can see the point that sometimes there's a very, very notorious case called the Qatada case about a suspected terrorist. Britain wanted to deport to Jordan, his country of origin, and it was not allowed to do that because in Jordan he was convicted in absentia, and it appeared that one of the witnesses providing evidence against him had been subjected to torture. That's very briefly the case. Now, the case has been discussed at 3 levels within the British judiciary: the Immigration Court, and the Court of Appeal, and then it was the House of Lords of the Supreme Court. And 2 courts came to the conclusion that Qatada could be deported. That's why the British government then said, why is it court becomes a court of fourth instance, tries to overrule the court which actually has done its job. I can see the point. I can also see the point made by the court that sometimes, even though the national judiciary has made an effort to give an equitable judgment, there may still be room for the court to intervene. Do you want to say something about it?
Well, I think I did do myself out of the job. But no, I agree. It was submitted in the right declaration as an idea, but I think that there are difficulties in implementing it also because of the issue of being a court of fourth instance. And how would you practically have to implement that? I mean, the court would have to do a lot of work to assess what was done at the national level and whether that was adequate or not. So it may not end up saving the court time in terms of dismissing cases. But I think it is something that they're looking into.
Right. I see you figure down there. Anyone else?
Hello. Yes. Okay. My question is the following. You said that, or you made a point that the European Court of Human Rights is losing its legitimacy.
It's credibility.
It's credibility. Thank you very much. It's credibility because of the fact that they're not following up on their precedents.
Yeah.
But you didn't really sketch how often does it happen that, how many cases are there that they don't follow up on. You gave a few examples, but you didn't give the full picture of how often does it happen, and how often does it happen in regular courts, in the Dutch court or in the English court. Anyway.
That's a great question. Thank you very much. I'm not sure. I didn't count the number of cases in which the court didn't follow its own decisions. I've seen a number of cases where that clearly has happened. Let's say 20. But that's not the point. I would say that the court at the pinnacle of the rule of law building should never disregard its own precedent. Full stop. That's what we expect. The court is there to abide by its own precedents. How else is it going to provide legal certainty which is necessary for any legal system to survive? So the fact that the court has once or twice, it has done it far more often, it has done so once or twice, I would say that already is a loss for the court. Then again, I would understand if the court would say, okay, we made a mistake, shouldn't have done this, oversight, no problem. We will never do it again next time. That's not what the court is doing. The court is saying that people like me who complain about this are looking for problems that are not there. Because the court says we have appointed a person, and Julie, I think, referred to that, called the Jewish consul. It's a senior official in the court that has the duty to guard the consistency of the case law. Well, I have to say, I don't know who the person is, but he's not deserving the money he's been paid, by the way. But that's not the point. A court should be aware of its own case law. As a judge, you should be aware of your own case law. This happens in Australia. If you would go into any court in Queensland or New South Wales, every judge on the bench would be aware of the case law covering the case and would ask counsel to come up with cases supporting the argument of the plaintiff or the defendant. It's not what happens in Strasbourg. It is a kind of paradox. You shouldn't complain. There's an article written by the former president, Costa. I think it's outrageous. He says, yeah, sometimes we make mistakes. Can't have it right every time. Well, we are burdened with a huge case law. I would say you can get rid of the mistake and the case law in one go, so do it.
I would just add to that, being a common law myself, obviously precedents in the lower courts is always binding, and that is the law itself. So I think in Australia it's probably different, but you never stray from precedents if you're a lower court. It's only the superior courts that can. So in that sense, it is quite a landmark when a constitutional court or a Supreme Court or a High Court does regulate some precedent. two examples I can think of, which are the main cases everybody studies at law school, that dramatically change the legal framework. But that's because of the common law system. I think the European Court operates under a slightly different system, and I think also with new instrument interpretation of the Convention as well, that the Court doesn't necessarily say we made a mistake earlier, but they say things have changed. Standards in Europe have changed, or technology has developed such that these are now issues that previously weren't, or that would have been dealt with earlier. So I don't think it's necessarily an issue of saying we were wrong and now we're right.
Perhaps a brief comment. I do not object. I'm not a fan of the living instrument of personal law. I will state that case, but it's a choice of the court. I respect that. But as long as you choose that particular approach, you have to stick with it. I have no problem at all, and the High Court has done so in a gentlemanlike manner. They sometimes say, well, we decided something in 1950 in the Communist Party case, and perhaps it was not wisdom personified at that time. It's now 2012, and we changed course. They have a discussion among your honors about the worth of the precedent, and then perhaps move on. That's as it ought to be. We now find cases where the court is oblivious of its own precedents. It doesn't know that it has decided a case in a completely different manner on a similar set of facts. Again, don't take it from me. The current president of the court is called Sir Nicholas Branson. He's a very respected British judge. He wrote a dissenting, I would say a vehement dissent in the MSS case, which I keep mentioning. And there he said, it is outrageous that the court does not accept Belgium's position that it was relying on the court's case law, actually decided 6 months previously when it decided to deport that person to Greece. So it is the court not being aware of its own case law that the word sloppy, I would say, is even a mistake.
Ik zie achterin een vinger.
Yes, thank you. I was wondering with regard to the discussion on the legitimacy of the court. This court can't really have popular support as a source of legitimacy, I'd say, because as we've seen throughout the European Union, the support of the popular vote, so to say, is geared mostly towards, especially during the crisis, it's getting more and more towards a national government, towards national institutions. So is it not slightly, well, unfair is a big word, but I don't know how to put it differently, to measure the legitimacy of the court by comparison to, for example, an American case where indeed the court is maybe a symbol of the state or the national state that people might feel more inclined to support, even though I'm aware that in America maybe people are not that fond of the federal government, but that could be perhaps an explanation for the difference in popular support, right?
Well, I would agree with you, but for the next point, the only thing the European Court has in common with the European Union is the word European. Because the European Court of Human Rights is outside the European Union. It has nothing to do with the European Union, although in the future a link will be brought about. But that's the future. So if people would associate the European Court of Human Rights with the European Union, they would be wrong, and I would not agree with it. The problem is that your point doesn't cut ice because nobody in this country, nor anywhere else within the European Union, has a problem with the European Court of Justice, the court of the European Union. It has a high popularity rate. So there's no reason why any aversion people might have against the European Union, and that's widespread also in this country, I agree with you, should translate in any rejection of the case law of the European Court of Human Rights. I think Penny needs to interview.
I have a question.
The microphone is coming your way. Somebody over here. Penny is a colleague at the School of Human Rights.
Thank you. I think you are a supporter of the legitimacy of the court. And legitimacy, as you've mentioned, is based on the popularity and democracy, like that. And I think the essence of popularity of the democracy and the opinions is based on the current scenario, and then they're coherent with each other. So I think then we can say that you are a supporter of the legitimacy of the court, and legitimacy is based on the popularity and democracy of the people and their opinions. And their opinions is based on the current scenario. Then I think it's a coherence, right?
Well, thank you very much, Penny. There is a colleague who has joined our staff, our faculty, very recently, 3 days ago. She's from a graduate from Wuhan University in China, and she's pursuing a PhD right on the topic of today, the activist interpretation of treaties by judges. So I really like the fact that she's asking a question. We have agreed, Penny and I, that we will never agree, so I don't agree with you, and I'll explain why. Legitimacy is not the same as democracy. Legitimacy, of course, Judy she's a great debater, so she made a point that legitimacy has to do with popularity. It doesn't have to do with popularity, because the decision taken by the Supreme Court in the US in the Bush v. Gore case was hugely unpopular, but still people feel that the US Supreme Court is the legitimate judicial institution. Legitimacy is more complex than that. And you coming from China, perhaps I may use your wonderful country as an example. The leadership of the Communist Party in China has no democratic legitimacy, but it has legitimacy. If you look to opinion polls in China, over 70% of the Chinese people believe in the guiding role of the Communist Party of China. I can assure you that many politicians in the Netherlands would really envy the party for that. So legitimacy is a bit more mythical than democracy. Actually, in China, we have the mandate of heaven. You know that, of course, very well. The rulers of the country are supposed to rule the country as long as they do good to the people. And of course, the rulers of China try to do good to the people every day, because you never know. If people start to complain, then you lose your legitimacy. That's why the Chinese leaders are doing their utmost to get jobs for the people, to get good trade agreements in Africa. And they will never stop. They do it around the clock. So legitimacy is a little bit more complex than democracy. I believe that the European Court needs legitimacy because it doesn't have the power of the purse or the sword, and it's especially handicapped by the fact that it's an international tribunal.
Just one question. Maybe I oversimplify the term of legitimacy, but are there any circumstances that legitimacy will be coherent with judicial activism?
Yes, there is. I always try to avoid the word judicial activism, because what the one person considers to be judicial activism, the other person considers to be self-restraint, the opposing word. And I will illustrate a point to you. There's a famous case, and you referred to it, the ABC case about abortion. It was a case brought against the Republic of Ireland by women who were refused the opportunity to undergo abortion, in one case even under life-threatening circumstances, and also the right to go to Britain to undergo an abortion there. The court wisely, in my view, tried to avoid getting involved in the issue. So they said, we're not going to discuss whether or not Ireland is supposed to have the right of women to have abortion into its national legal system. That's activism, because it tries to pursue a particular political agenda, which I agree with, by the way, but it's a political agenda. But it did so by interpreting the convention in a very restrained manner, as saying that Article 8, which is about private life, does not cover the right to abortion. It's a very restrained position. So activism is not a good word. I would say a court should be a proper judicial institution. It's the only thing I would like to say. But sometimes outcomes I don't like, it's all in the game. Of course, you sometimes don't like the outcomes. I don't like all the outcomes of the US Supreme Court, but they're all very well reasoned.
Can I say that command interpretation is actually a neutral term? As if in the
we not better. We will continue our discussion.
All right, so continue. Anyone else who would like to pose a question? Are we all baffled by the questions just now? William.
I have two questions. The first one is actually directed at Julie, and it's about the Living Institute approach. I'm not a legal theorist, I'm a physicist, I'm not a legal theorist or a politics major or anything, so you can explain a bit more perhaps about that. But I was wondering about that. It seems to me, and the point was indirectly raised by a few other people who asked questions, that it is very hard for a court which actively interprets and tries to add new rights or new law, which I think is more or less what the living instrument approach entails. It seems hard to me for a court to do that if it does not have, indeed, if it does not have legitimacy, if it's not perceived as being of the people. And it seems to me that the point raised before, that we as Europeans are perhaps less of a coherent society of values than we might like to be, and some of the elites might like us to be, but we might be less coherent than a national Supreme Court or than even a US federal Supreme Court. And if that is so, I was just wondering, is there a general theory where a court, the further it's away from its people that it's ruling over, and I mean 47 countries is a lot, it's not just the EU, should then this court be more restrained, more conservative in how it interprets its rulings and what it does, or do you think that this does not apply either generally or in the case of the Strasbourg court? Secondly, a question to both of you. I've read in The Economist that some British courts indeed are saying, some commentators are saying that the judges on the Strasbourg Court, on the European Court of Human Rights, vary in quality as a, thinly veiled way of saying a lot of them are incompetent. Do you share this sentiment? It seems to me like Professor Zwart has some sympathy towards this stance. And if so, what is the cause? Is it because there must be nationals from all the member states in the court, or is it for some other reason? So thank you.
Thank you. I'm very impressed with those questions, particularly from a physicist. I know absolutely nothing about science. I thank you for your questions because they were very insightful as well. I think the first point I would like to make is in relation to the US, because it's often used as an example of a court that has a lot of legitimacy, and that may be very true, but there's also a lot of skepticism in the US about international law. The US is not signed up to a lot of international conventions, including a lot of basic human rights conventions, and also obviously the ICC. And oftentimes Americans get very upset if international law is used by the Supreme Court to interpret either their constitution or other forces of law. So I think that there's a difference there. I think someone else earlier mentioned that for the Americans, it's still Americans judging Americans, whereas I think they would be very upset if an international body tried to adjudicate laws or their practices. So I think it's not a direct comparison in terms of legitimacy. And what I do think is important about the European courts is that it has a legitimate process. I don't think it's necessary for its decisions to have legitimate or popular support, but I think the process does have to be sound. And that was one of the questions I posed to all of you, whether the court should progressively lead the charge, it should be interpreting things and reading new rights into it, and we've got this and this, and now everything's changed, so we're going to have a right to environment and all sorts of things. Or whether the court should somewhat more cautiously follow behind public opinion. And I think that it is very difficult to change the convention. It's not like legislating in the national parliament. So I think in that sense the court does have to be somewhat creative when it is interpreting the convention, because it does have that disadvantage. But personally I think that the court shouldn't lead the charge. I think that when governments fail to act to support or uphold rights or protect minorities, then the court should step in. But I do think it should lead the charge, because I think that does then create difficulties in terms of its legitimacy. And I think that also feeds into the process, is that it should follow along with public sentiment to an extent.
to make 3 short comments, but I will preface it by making an apology because I will have to leave in 5 minutes as I discussed with Chris. It's not that I don't find the discussion not very interesting. I would say, if you look at the United States, just take the car from New York City and drive up to upstate New York, and within half an hour you will find people with a completely different worldview from the people of New York. So that's what the US Supreme Court is dealing with as well. The country is evenly divided on the question whether or not women should have the right to abortion. And they're grappling with that issue for decades now, and I don't think they've found the right answer. I'm not so sure whether our values are very different, and if they are, we can't find a solution. Every state that has signed up to the European Convention still has to implement the decisions of the court. What the court has to do is not to alienate its natural allies. Just to give you one example, I'm very, very respectful of the Russian Constitutional Court. I had the privilege to work with the court some years ago. The president of the court, Valery Zorkin, is the man who impeached President Yeltsin because he wasn't sticking to the constitutional requirements at the time. He's a giant. He's a very small man, but he's a giant intellectually. What the court has done is to try to translate the case law of the court consistently into Russian legislation. Has been the biggest supporter of the European Court of Human Rights across Europe. Recently, in a decision about a man in the Russian army who wanted to have 3 years leave as a parent, because women have that right in the army in Russia as well, the Constitutional Court came to the conclusion that that would be contrary to Russian views on maternity and the role of the woman in society, based on research. It was not. And then the court said that the Russian Constitutional Court is engaging in gender stereotypes. Well, the court, as you can understand, is outraged by that. And your final point, I don't agree with the point that the court in the judges is substantive.
All right. Well, thank you very much for answering these questions and the whole further debate. This will conclude our lecture for today. And so I may conclude as well for myself. I think we all hear that human rights are very important, but we should never look away and always see if they're applied in the right way and not take lead themselves. So, everybody, warm applause for our speakers. Tom Zwart. We have a little gift. Didn't know that we were gone. SIB to do their and well, I guess our speakers will have to leave because they have to catch a train and still make a journey home. So they won't join us for that, but of course you are all invited to stay. All right.
I will continue in Dutch. En dit wordt even aan Oscar.
Nou, ja, mocht u denken zo'n dat dan is zoiets voor mij, om lid worden van SIB, leuke lezing, gezellige activiteit. Jullie kennen jullie opgegeven, het infokamp weekend deze vrijdag en eindigt zondag, die wordt dan weer terug naar Utrecht. De staande leden mogen ook mee natuurlijk, het wordt erg gezellig.
We hebben elke week een lezing, zo volgende week. Volgende week gaan wij het hebben over Wit-Rusland. En feitelijk de enige dictatuur van Europa. En ja, de vraag gaat van hoe gaat het in het land en wat gaat dit land samen. Frank de Hummels komt hier over praten. Dus kom allemaal. En dan nog een lezing. De week daarna van de Rutger Bregman. Je ziet hier op de foto, een hele mooie foto. Over de geschiedenis van de vooruitgang. Waar het echt over gaat is het verschil tussen wat Nederlanders voelen met zelf gaan. Maar en ook hoe het met Nederland zelf gaat. En daar zit een heel groot verschil in. Het is eigenlijk het grootste verschil van heel Europa. En daar gaan we het over hebben.
Na die interessante lezing geeft het Genootschap voor Mensenrechten en Ontwikkelingssamenwerking een workshop in Punks over humanitair oorlogsrecht in samenwerking met Rode Kruis. Mochten jullie geïnteresseerd zijn, kan je opgeven bij mos@SIB-Utrecht.nl. En dat was het. Dan gaan we nu naar Bob. Ja?
Oké, vragen? Die mos-workshop, waar is dat? En kan je daar ook iemand meenemen die geen lid is?
Ik denk dat je dat met het genootschap zelf zou moeten bespreken. Jij kan wel een mailtje van naar mij sturen, dan leg ik dat aan. Nou, dan nu de Bob. Als je het gebouw uitkomt, 3 keer naar links en dan sta je rechtsaf tegenover de aanval. Dus kom allemaal mee.